Hello, everyone. This is Kristen with the LTRC. Thank you for joining us for Document Review Bootcamp, the ultimate guide for increasing client satisfaction with our sponsor, Exterro, as part of the LTRC Industry Insights series held every Wednesday. Our speakers today are Mike Hamilton, David Cohen, and Brenda Dodd. Thank you all for joining us. We will now begin the webinar.
Thank you, Kristen. My name is Mike Hamilton, and I welcome you to today's presentation. As Kristen said, this is Document Review Bootcamp, the ultimate guide for increasing client satisfaction. This webcast is being brought to you by Exterro. And Exterro, just to give you a quick word about who Exterro is, Exterro empowers legal teams to proactively and defensively manage their complex legal governance, risk, compliance requirements. We are the only software provider offering a comprehensive legal GRC software platform that automates the complex interactions of privacy, legal operations, digital forensics, and cybersecurity response. Thousands of legal teams around the world within corporations, law firms, government, and law enforcement agencies trust our integrated legal GRC platform to manage their risks and drive successful outcomes at a lower cost. And just to give you a quick overview of what we mean by legal GRC. So what we've observed over the past couple of years is how you treat data is key to addressing so many of the concerns facing your organization or firm. How an organization collects, stores, uses, and secures its data ultimately determines the extent to which that data poses risk, incurs cost, and provides value. Forward-thinking legal departments and law firms are implementing a new strategy for optimizing their processes in managing their data. And that's where Exterro's legal GRC software platform is focused. With a modern enterprise class data inventory, one that can tell you where your data lives, what regulations it is subject to, who owns and has access to it, you can begin to address requests for data like you see within a data subject access request or within litigation. But it's not just enough to know where your data is located. You need to be able to actually connect to those enterprise data sources, the apps, servers, databases, where the data is stored to validate the information in your inventory. You need to know not just where the data is, but how much you have. By having this information, you can now constantly manage, analyze, and respond to requests for your data. And that's really what Exterro offers. Our products help you address these big business risks. With intuitive, easy-to-use software, your legal team is no longer jumping from multiple point solutions, but can leverage one user interface that is built with repeatable, consistent workflows across multiple areas of interest. So that is, in a nutshell, what we mean when we say a legal GRC platform. So now that you've learned a little bit more about Exterro, let's learn more about our tremendous speaker panel. Really feel grateful that we have these two great speakers on today's presentation. Our first speaker is Brenda Dodd. She is the Director of Product Management at Exterro, but had extensive experience in-house. So Brenda, do you mind expanding on that experience for us?
Sure. Hi, everyone. Welcome to the webinar today. As Mike said, I currently am the Director of Product Management here at Exterro, focusing on our review products. But prior to that, I started out my career as a paralegal and eventually found my way into the corporate world where I managed e-discovery for 3 of the larger corporations in the Pittsburgh area where I am currently located. So during that time, I spent a lot of time coming up with processes and procedures as it relates to how the corporation should be tackling the pre-litigation aspects of things. So I'm looking forward to today's conversation.
Thank you so much, Brenda. And our second webcast panelist is David Cohen. He is partner at Reed Smith and chairs the Records and e-discovery group there. Dave, thanks for joining us. And do you mind giving us a little bit of background about yourself?
Sure thing. Thank you, Michael. And I'm delighted to be on a panel with my old friend, Brenda Dodd today. Our group, which is about 70 lawyers in the Records and e-discovery group, the thing that we spend the most time and effort on is document review and analysis. So that has been I've done all types of commercial litigation, but my focus over the last 20 years has been trying to figure out the best ways and the most efficient ways to do large-scale document review and other e-discovery for litigation.
Well, thank you, Dave. And what I'm really excited about this panel is we have two really unique perspectives here. You have the law firm perspective, and then you have the client in-house perspective here. And Brenda's got that technology background as well. So should be a really insightful 30 minutes for all of you here today. And I'd like to thank everyone in the audience for joining us here as well. One more housekeeping item: the commentary positions discussed by our panelists today are just that, they're commentary positions, and do not necessarily reflect the positions and thoughts of the organizations they represent. One other thing, please don't hesitate to use that question box in the Zoom chat. Please do, if you have any questions, we'll have a Q&A period at the end of the presentation. So please do submit those. Our speakers would love to answer those for you. So document review is the most expensive part of litigation for your clients. Oftentimes, legal teams are looking for new ways to efficiently review documents, but that's only really half the challenge. What legal professionals also must be assessing is how much data is actually making it to document review, and if there's a way to potentially scope down that data in the first place. So in today's presentation, you'll learn how to review documents faster, also create a document review workflow that hopefully can save yourself and your clients time and money. So let's start by discussing the benefits and goals of having a repeatable and defensible review process. So the first goal or objective, hopefully you have attending this webcast, is all about getting to the heart of the case faster, to make those try or settle decisions. And that really starts with narrowing the document review funnel. But even to get there, you should try to get to the smallest amount of data at the start of the review process. So Brenda, we've talked about this, just me and you, but how important is it to take each one of these stages that you see here seriously before focusing on that document review aspect?
Well, Mike, I can't stress how important it is, really. What's that saying? An ounce of prevention, right? So a lot of common mistakes or issues that arise during a legal review are really probably directly related to not having these standardized procedures and not being properly prepared as it relates to these early stages in the review funnel. For example, having effective records management policies, even a data map or sound retention and legal hold policies, they're really going to help you reduce that accumulation of unnecessary data, making compliance with discovery requests a lot less burdensome. I think a lot of organizations may focus heavily on the legal hold aspect, and they falter on the preservation aspect in some sense, right? So I would suggest, and what I tried to do when I was in-house was always to make sure that we had a preservation plan in place, which addressed how data was going to be preserved, where it was located, how are we going to go about addressing that when the time came to collect it. And I think all of these things are really going to significantly increase the effectiveness of your collection. It'll really put you in a better position to be able to focus on what may be relevant to the issues at hand. And I think that it'll also help you avoid potential risks down the road.
Yeah, and that's really great insight from the in-house client perspective. So Dave, having heard this work, I'm sure you've worked with thousands of different clients. You've heard approaches similar to Brenda's. How do you partner with them? And what's your mindset and goal in starting the document review process?
Yeah, I think Brenda hit the nail on the head. You start these days with thousands, hundreds of thousands, or even millions of documents. And you do have to cast the net broadly in terms of preservation, because you don't want to be guilty of any spoliation. But your effectiveness is directly related to how quickly and efficiently you can get down from that broad universe of available documents to the documents that really matter. And we all know from litigation, usually cases turn on at most a few hundred documents, and finding those key documents in the population as quickly and efficiently as possible is key. So I like this, this funnel idea. You're funneling down, and where I would put the focus is in this diagram right between the collection and / processing and the review, because it's in the review piece that you really start hitting these most significant costs. The more you can do to narrow the collection, get rid of irrelevant documents before the review piece starts, the more successful you're going to be, at focusing on the relevant documents and minimizing your costs.
And Dave, I mean, and Brendan, you probably can speak to that. That speaks to client satisfaction right there, right? So instead of sending over millions of documents to Dave and his team to review and spending millions of dollars, you're cutting down on that. I mean, Brendan, would you agree?
Oh, definitely. I mean, I can think back. I've been doing this for a long time, and early in my career, especially in house, I would get our outside counsel. And sorry, Dave, I'm not accusing outside counsel of anything, but they wanted us to really, oh, just give us everything, right? To do a search on the broadest terms that you could think of, and we'll call it down. And I really tried my best to put a stop to that when I was in-house, because it just didn't make sense to me. Ultimately, I want you to be able to quickly get to the point of the case and the merits of the case and focus on what you should be focusing on. And I don't want to send you all this non-relevant stuff. So to me, it was, very important that I had that relationship with my outside counsel and that we could kind of work through those details.
Well, let's talk about that a little more, and this idea of standardization and how you work between teams, if they're internally or externally. And that's really what we're going to be focusing here on this presentation is how do clients like yourself, Brenda, work with people like David so that you are finding that synergy, that's going to make you, Brenda, happy as the client. So, how do you really start, Dave, in your opinion, to streamline this communication and to standardize it so that you're getting this outcome that Brenda was talking about?
Yeah, so I think that where you get ahead of the curve is if you have a process already set up, and that's what we do. So on that sort of inside-outside divide, I don't consider myself the outside counsel piece because many companies bring us in to manage their discovery in cases even where we're not merits counsel. They hire us as discovery counsel to make sure that that population is narrowed down and that we're not overdoing it on the e-discovery area. And so having processes in place, and especially important is the focus on that filtering before you get to document review and the use of technology tools to do that. And I know you have some questions later about technology tools, but definitely as parts of the process, you want to be talking to knowledgeable people so that you're not over collecting and over preserving. And then once you start gathering data, you want to filter not only traditional deduping and email threading, but using what we call early case assessment tools to cut out irrelevant documents. Search terms still have an important place, and many firms and even inside counsel sometimes make the mistake of just coming up with an initial set of search terms and running it. You can really get a lot further by running through multiple iterations and testing your terms. And this is where you get to defensibility. You need to test not just what you're collecting to make sure what's relevant is there, but also you need to do some sampling of what you don't want to further process so that you have that defensibility. And you can say, yeah, I didn't just exclude these, I tested, I did sampling of the documents that didn't hit my search terms. And so search terms, certainly negotiations with opposing counsel, and you're certainly, if you've done some analysis in advance, you're in the driver's seat in those negotiations. And then technology assisted review. Those are some of the key tools in cutting down what you've termed the most expensive part of the process. My goal is to make sure it's not the most expensive part of the process, because I think if you do everything efficiently, you can really knock down those document review costs substantially.
Thank you, Dave. And Brenda, can you talk about, in your prior lives being in-house, like how did you go about standardizing these processes between yourself and someone like Dave?
Well, absolutely. I mean, I worked with David or others, of our outside counsel in developing our standard operating procedures or SOPs that outlined all of our processes, whether it was related to preservation or collection. And these are constantly being reviewed and updated as necessary. Particularly after any significant discovery or review project where we'd always do like a post-mortem to evaluate how effective those procedures were. So it was kind of a continuous improvement process. I think also equally important is to really make sure that the organization also understands their roles and responsibilities as it relates to these process and procedures. and making sure that they're being followed. It's great that you have them in place, but if they're not being adequately followed, then that's when you may find yourself getting into trouble. But I always tried to make sure that I worked hand in hand with our outside counsel so that they understood what our internal processes were. And ultimately that really helped us become more efficient. We were able to quickly focus in on where the data was and who the right people were as far as custodians. So I think that that's really important.
Yeah, it's that collaboration, right? Where it's not
Exactly.
just here's the case file, here are the documents, go do your thing, right? It's
Exactly. I mean,
partnership.
Dave mentioned, those keyword terms, and I can't tell you how many times I worked hand in hand with, we would just go back and forth with not just the outs before it even went to the opposing side, right? We would talk internally or with our outside counsel on which terms made sense. I would do some of that early case assessment, do searching and say, well, this is what I'm finding. Maybe these terms aren't what really are they're not picking up what we need to find here. Let's talk about this. How can we improve this process? How can we find exactly what it is that you need that's relevant, that we can get to quickly?
Let's move on and let's talk about, how do you actually do this? What are some strategies? And I know we've touched on this a little bit, but let's dive a little bit deeper into the details here. And I think the first thing that you want to do is really have that strategy on how you want the review process to fit into your overall pre-litigation workflow. So on the slide here are a couple topics that I want to discuss with. I think can really have an effect on what documents you actually start to review. So David, can you discuss the concept of proportionality and how that ultimately affects what documents you are reviewing?
Yes, the concept of proportionality is near and dear to my heart because when I started as a practicing litigator, the basic rule was whatever the other side asked for, you had to give them. Anything that was relevant or could lead to discoverable evidence. And proportionality, maybe there was some language buried in the rules, but it was not front and center. And so we worked hard to get amendments to the rules to take account of the tremendous cost of discovery, which was making litigation so expensive. And in fact, I testified in support of the amendments to the federal rules that added proportionality. And I was on a small drafting committee that drafted the amendments to the Pennsylvania rules along the same lines. And we got what we were looking for. The rules now say not just relevant, but relevant and proportional to the claims and defenses in the case in terms of the scope of discovery. So the problem is that now we've got the language, but too many attorneys aren't using it. They're not taking advantage of it. They're not pushing proportionality. And it's essential that you do. And it's not just for small cases. While it's true that more discovery is justified in bigger cases with more at issue, it's still not unlimited. It still needs to take into account what's really needed to resolve disputed issues in the case. And so I think that focusing on proportionality, and that's one of the things we do when we're brought in as discovery counsel, having those conversations, first internally to see where it makes sense to narrow, then trying to negotiate with opposing counsel. And we've actually had pretty good success with some opposing counsel, not all opposing counsel. But when you run into the recalcitrant opposing counsel, we're asking for everything under the sun. That's when you take advantage of the rules and bring in the judges and you file a motion for protective order or a motion for cost shifting. And so through those kinds of techniques, we have been very successful in narrowing the scope of discovery compared to where we were, say, 10 or 20 years ago.
That's great to hear. I mean, very beneficial for your clients. And Brenda, I want to move down to the second topic here, and that's the tiering/phasing. So once you get to that review process itself, how are you seeing legal teams strategize or plan when and how to review certain documents or certain documents from specific custodians?
Well, I think that, every case is different, right? And the process is pretty much always going to kind of look the same. There may be some different aspects depending on whether or not you're doing a standard review or a technology assisted review. I think what's really important too is to make sure that you have a review protocol in place so that all the parties in the review team are, they're understanding who the key players are, the custodians, the subject matter. But really, I think legal teams are really focusing on hopefully using analytics. So before they even start their review projects, they have a good understanding of the data. So by using such things as auto classification, the communication analysis to see who's talking with who, concept clustering or topic modeling to see, what they're talking about. All of these can really help the legal team focus on the most responsive documents and then enable them to make smart decisions on how to allocate those resources during the review process.
Yeah, I think that's a really good point. And a judge on a prior webcast used to always say, focus on the low-hanging fruit first and those are breadcrumbs to tell you more about the rest of your case. Don't just try to learn everything at one time,
right?
Because it's gonna be really expensive, and that's not what the court expects of you in the first place. David, last but definitely not least, we want to quickly discuss, privilege and what role that takes within the document review process. So can you talk about some best practices or considerations that you take into account when defining your privilege process?
Yes, and that really directly impacts workflow because you're going to review several different kinds of documents. You're going to review your own client's documents, and their privilege is front and center. You want to make sure you're not producing anything covered by attorney-client or work product privilege. Whereas when you get the documents from opposing counsel or from a third party, yeah, you still want to review them to see how they fit into the case and how you can use them, but you don't need to worry about privilege because they're being produced by an opposing party. So just like with review for relevance and responsiveness, you want to make the privilege review as streamlined and efficient as possible. And, for a long time, we've been using things like privilege key terms to help us identify probably privileged documents. I'll throw in a plug for the e-discovery app because the best version I've been able to come up with of privilege terms is listed there for free in the e-discovery app for anybody who wants it. And you add to that the names of the known attorneys so you can pre-identify privileged documents and help you make sure nothing slips through. I'm a believer in pushing down review to the lowest cost people to do that review. And often that is companies working for a e-discovery company, sometimes even offshore to minimize the cost. But as attorneys, we then have a duty to quality control that. And so that usually means reviewing at least the privilege calls and a sampling of the relevance calls so we can make sure that the others that aren't authorized to practice law did a good job. And so you want to sort of streamline the higher cost review to focus on privilege issues. There was also software out there beyond just search terms that can help using artificial intelligence and some of the things that Brenda was talking about in terms of relationship analysis and who's talking to whom to help you identify privileged documents. So you want to do that as efficiently as possible. And there's also some new protocols which can save other costs, such as the high cost of privilege logging. I highly recommend the EDRM privilege protocol, which I helped to work on, and streamlines privilege reviews by focusing the log on the metadata that's available for free so you don't have too much extra human time involved in producing the privilege logs.
Really good tips there. And I'm glad you started talking about all these different parties here because it's a great segue to this next slide. And, it's really defining that review workflow and all the parties and roles and responsibilities that go into that workflow. So Brenda, can you please describe how you went about defining roles and responsibilities at some of the prior places of work around the document review process?
Sure. I mean, so internally, in-house is a little bit different than, say, what you're going to see specifically with a managed review project, where you're commonly going to see the managing attorney and then the project manager, or the review manager, the reviewers, the QC team, and maybe a technical administrator. But from in-house, it really just depends on the size of the organization. But one thing that I do want to point out, in addition to the legal team, so you have the attorney who's responsible for the case, you'll have the paralegal that's working on it, you may have some type of lit support, but you really should have someone from the IT firmly on your legal team or that's dedicated to help with those early stages of the collection, identification and collection process, because a lot of folks may not see them as key players, but they really are. I relied heavily on them. I needed them when I needed to collect the data. I needed to identify where my data was. So I think it's really important that they're involved and they also understand their responsibilities as it pertains to the legal needs for a collection and review process.
Right. Well, in the matter of time, let's just skip ahead here into the different workflows and, talking about some of these elements that have already been referenced a little bit, early case assessment. So David, do you see your clients having standardized review workflows across different matter types, and what considerations should be accounted for when defining different review workflows?
Yeah, so the workflow should vary, and it should vary based on the complexity of the case, based on the volume of documents, based, as we noted before, on whether they're privileged documents or a high percentage of privileged documents. So all of those are considerations, and the goal should be to drive down the work. Once you've used technology to narrow the review as much as possible, then drive down the work as much as possible to the lowest cost people that can do it. So as I noted, sometimes that means using an e-discovery company. Sometimes we've had even great success collaborating with offshore review. But then there does come time for law firm review, and that's where I'll put in a plug for a group like mine, which is lower cost than traditional associates, e-discovery attorneys, but they can do that supervision and that first level quality control at much lower cost. So you're saving clients money at that place as well. And, limit the review as much as you can. There's times when because of the amount at issue in the case and the volume of documents, we produce some documents with minimal review, just sort of keys to the warehouse approach. But you need to make sure that you're not producing privileged documents, and you need to make sure that you at least know the important documents, hot documents that really are important in evaluating your case and evaluating the other side's case.
Hey, Mike, and just like Dave, he wanted to, I want to make a plug as well. So on the technology side, as a product owner, I do want to point out that a lot of these review platforms now can, or at least they should have the ability to automate the review process. So for example, with Exterro Review, users can set up automated review batching. So as the documents are passing through that tier, that phase that we talked about earlier, they can automatically move to the next phase. For example, after a first pass reviewer tags a document as relevant or responsive, then it will automatically populate the privileged reviewer or the issue reviewer's batches, so that they're not sitting around just waiting for documents to come to them. That could happen automatically. So that's something that should be taken under consideration too, as you're doing your review or contemplating a review, is the type of technology that's available to assist you.
Well, Brett, I want to stick with you real quick here. So let's talk a little bit about security, right? As the client, right? Like, you want to ensure that, if there's a data breach, and it's not an if, it's more of a when, right? That, that data is secured, and who knows their environment better than the client, right? So can you talk about sort of that role that security plays in the considerations and when you're potentially sending documents out for review to a law firm, if it's having the law firm maybe come into your review platform instead of going into having them do it in their own review platform? Can you expand on that a little bit?
Sure. I mean, I think this is a really timely topic, especially given the ever increasing hacks and data thefts, cyber threats that we're seeing. As you put out, as you go through the process of a review, your data could be transferred multiple times between, various partners, between outside counsel or third-party vendors, experts, even, sending it to opposing counsel. I mean, we're all working from home. So, your reviewers could be accessing documents, and downloading them or doing whatever. So I think that security really needs to be a high consideration. And some things that you can do to protect your data is really making sure that your vendors and clients have those strict security certifications and protocols in place, making sure that the data is encrypted at all times, employing single sign-on or other multi-factor authentication, taking the measures before the data is even collected, that can help you protect some of the sensitive information, like making sure that maybe PII is redacted or masked before it even leaves your organization. I think the most secure e-discovery platforms are those that can help you eliminate the risk by providing one central location, like you said, Mike. So maybe the ultimate goal here is that, yeah, we have these corporations allow your outside counsel to come in and do your reviews behind your firewall where you can do that. I know that's not always going to happen, but in an ideal world, that may be the best solution.
Yeah, no, that's a great point. And Dave, I'll let you touch on technology here just to sum it all up. What are those key features, functionalities that you see in document review technology that may not be, or that may not come top of mind for a lot of people that you're obviously privy to, being so such an expert in the space?
Well, I definitely agree. Security is taking on added importance, and there's added risk with so much remote work. And so features that enhance security are great. We're starting to see, and Exterro is one company at the forefront, integrating general document maintenance and document management with the e-discovery process. And having that all integrated can really be key to saving. And then the increased use of artificial intelligence for things like privilege identification, predictive coding, and relevance identification, even redaction, which Brenda mentioned. There's now, software tools which help you redact documents quickly. One other thing I'll say on the security side is, we as lawyers will tell you also get a protective order before you produce anything sensitive. But a protective order is only a protective order. And if you produce documents to somebody that doesn't protect your documents, you still could suffer a lot of reputational damage if you're a big company and personal information gets out. So do take advantage of redaction. And in some circumstances, it's appropriate to give other parties access on your secure platform. If, say, they're in a small plaintiff's firm and they may not have the same kind of security, have them access the documents through your platform in the first instance, and then only take what they really need for the litigation.
That's really good advice there. And because we're pretty much out of time here, we did quickly just want to touch on this, and so I'll just talk about real quick here, is really evaluating document review success. And, if you are the law firm, having those postmortems with your client, as Brenda talked about, having reports that really showcase how much you're spending and the key KPIs that your client cares about, that's going to allow you to have that synergy and increase that client satisfaction so that they're going to use you for additional matters. So we are out of time. I know we have time for Q&A set aside, but really big thanks to Brenda and Dave for taking time out of your busy schedules to share your expertise with all of us here today.
Pleasure.
Thank you. Pleasure.
Okay, so like I said, we will have Q&A here, but one thing that we did want to plug real quick is, Exterro Review has come out with a new document review solution. We are offering a free trial of this. You get 6 months free and 5 terabytes of data storage. And so it's a no cost to you to try our new solution. And if you're interested in learning more about it, please go to exterro.com. And again, this is completely free, so it can't hurt to try. So if you're interested in following up with any of our speakers today, their email addresses are listed here on the screen. So we'll keep this up as we get to the questions that we received. So the first question that we received from the audience is, how often do you have to bring in an external forensic expert to recover/restore data? And when do you make that decision to outsource that?
Mike, do you want me to start on that one?
Yeah, Dave, why don't you kick it off?
Okay. Well, it often depends on your IT department, how sophisticated your IT department is. Obviously, if you can do anything you can do internally is good, but you also have to make sure that you have a proper chain of custody and that type of thing so that you won't get into trouble in court. You're not changing any metadata, et cetera. So it's often good to consult with outside forensics experts. We have a team of 40 or so in our technology subsidiary, Gravity Stack. We also rely on, there's a number of great companies out there. And another quick plug for the eDiscovery app, I think we have 60 service providers listed there, including many that do forensic analysis. So if you're looking for somebody, take advantage of that vendor guide on the e-discovery app. I would say, and it directly answering the question, how often? Probably in less than half our cases do we actually need to bring in an outside expert. But when you do, you have those old backup tapes or, some issue with a archived system, legacy system that you don't use anymore. It's really good to have experts to help you retrieve that data.
But anything that you would like to add to that?
No, I agree with everything that Dave said. In my experience, in my past experience, I can only count maybe a number of times when we had to reach out to an external expert. And as Dave said, it was most likely related to the fact that we had a lot of legacy data and archived data, or data that was from, say, mergers and acquisitions over the years. And that's when we needed the help for them. But it was very few and far between, but it's been several years.
To kind of just touch on that proportionality topic, right? Of when a forensic collection is even needed in civil litigation, right? Like, I mean, that's something that you probably want to have a conversation with your outside counsel like Dave, right? To really understand, do I need to spend all this money on this? Is it proportional to my case? Okay, so we got another question that came in. Do you always work out a clawback agreement in case of inadvertent disclosure to the other side, or does it depend on the size of the case, number of documents, other factors? Dave, I'll let you start this off, but this reminds me of Judge Andrew Peck from the Southern District of New York in 502D, but I'll let you explain that a little more.
I'll channel Judge Peck here, and I'll say always, as Judge Peck says, this is your get out of jail free card. You can do a quick 2-paragraph 502 non-waiver order, and it's more than just a clawback agreement. It's also non-waiver. You want to make it as broad as possible. We have a form on the e-discovery app, again, keep talking about that, but a lot of good resources there. And there's no reason not to do that in every case, because, even in a small case, a privileged document or two can get through. And in a big case, almost always there'll be some privileged document that gets through, or documents, plural, that get through that you want to pull back. So I would say all the time, do one of these.
And just to clarify, Dave, when you say e-discovery app, you're saying that's all they need to search for in the App Store?
Yeah, if you go to the App Store or Google Play, just search for e-discovery app. It'll come up. It's free. It's a quick download. And there's a form of 502D order, which I think is Judge Peck's form. So
it is. It's his baby, right? Okay, one last question here. Can you elaborate on the ease of designating access and quickly viewing who has access to documents being shared? Brenda, do you want to talk about that one?
Sure, definitely. So any software, any app, or any application that you're using to review documents should have multiple ways to give you this information. One, users, when a user is added, they need to be authenticated so that you know when and who's getting access to the system. But there should also be an audit trail of all of the steps or everything that those reviewers have done, including when they're looking at a document, when they're reviewing a document, if they've redacted it. If your tool does not have those audit capabilities, then you really should be looking at other tools, because this is only going to protect you. Also, within those tools, you should have role-based access so that you know who is doing what and who has which rights and access to do certain things. For instance, you may not want your reviewers to be able to download documents from their, while they're doing their review. Imagine if you allow them to download a native email and then they open it in their email account and then they can send it off. So this is a great question and something that you definitely should be aware of. There's lots of protocols out there that can help you protect who is seeing your documents and what they're doing with them from within the applications themselves.
Yeah, and a quick plug for Exterro Review, right? Those role-based access controls exist within that solution. So if you're looking for that, try it for free. One last thing, the last question that we had, and it was mentioning the site for the good resources. Dave, I think we already touched on that. But one thing I did want to bring to people's attention here is if you go to Exterro's resources library here, Exterro.com, you'll see that we have a case law library, which Dave actually gives his expert analysis on a bi-weekly basis. We have an e-discovery maturity quiz. We have a basics of e-discovery, microsite. We have all these different things, a plethora of resources if you're interested in educating yourself more on the document review process, but just on the pre-litigation process, just generally speaking. So I think that's it for us today. I'll toss it back over to Kristen. Again, big thanks to Dave and Brenda for your time.
Thank you, guys. So yeah, that's all the time that we have for today. I would like to thank our sponsor, Exterro, and all of you for attending our webinar today as part of the LTRC Industry Insights series. I'd also like to thank Mike, Brenda, and David for presenting today. If you are curious about future webinars, please check out the ABA LTRC page or follow our Twitter at LTRC for updates. You can keep up with Exterro at exterro.com. We will now conclude the webinar. Thank you, everyone.